with the constitutional coup, a term that was disputed by some last week. But for most of us, this is a constitutional coup attempt so far. I think it's fair to say that the authors of this Amendment Bill number 3, did not expect the kind of response from the Zimbabwean population, not least from the Zimbabwean intellectuals and constitutional experts like Justice Mavedzenge was here. And I think those of you who followed the discussion on X last week will agree that the author, one of the authors of this Amendment Bill number 3, was taken somewhat by surprise and would have and had a torrid time. 5 hours of very difficult time for Jonathan Moyo last week. Jonathan Moyo is important to mention here because I think to the extent that he agreed to be on that X conversation, to the extent to which he has been busy defending this amendment in a very spirited fashion, does make him qualify to be quite central to this whole matter. Now, as we discussed today, we are, of course, in the beginning of the so-called 90 days of consultation. It raises the question immediately of why the consultation if there is to be no referendum. Secondly, when we hear Chinamasa say, as he did yesterday, after long silence, having been the one who warned more than a year ago in Bulawayo that there would have to be 2 referendums if this kind of amendment would go through, suddenly came on the scene yesterday after long silence and made that emphatic statement: there will be no referendum, full stop. Now, the question of referendums are very important in the history of Zimbabwe with regard to constitutions. I was a young graduate in 1971 when I worked with the 2 Edsons, Edson Sitole and Edson Zobo, to fight the Pierce Commission. Maybe people like Justice are too young to remember. I don't think you were born even then. But it was also the similar background to what we have now. The British believed that the Zimbabwean people were battered enough, the national leaders all in detention, and that they could pull a fast one and get through the PS Commission, which was meant more or less to bless UDI, bring Ian Smith back into the arena of so-called civilized nations, make peace with the British government. And so the PS Commission was, at a very short notice, launched in 1971. And people came together very quickly, mainly Chinamano from ZAPU, Edson Sitole and Edson Zobo from ZANU, and decided to create a broad alliance, such as we see under the DCP, for which Jameson Timber is a convener, and brought everybody together, churches included, to fight this PS Commission. And it worked. It worked because at a meeting at University of Rhodesia then, we decided to appoint or elect Bishop Muzorewa in absentia as head of that coalition. the ANC at that time. Now we see a very similar situation now, where even though there's no referendum, it appears that the Zimbabwean people, and in particular the leadership thereof, in the form that we see, the DCP, CDF, and indeed such discourses as we're having, have already made enough noise to show up this attempt as fragile, essentially. And that if it has to go through as the authors intend, it will be a Pyrrhic victory, an empty victory. It will leave the system, the regime, very wounded, no doubt about that. And one must have as a possibility that they might just pull it back. If you remember, Mnangagwa pulled back in March last year because of the challenge the Geza had made for the 31st of March. It delayed it. And again, last year, when there was a bit of fireworks in the Politburo and cabinet over this matter. So this is the third bite at it. And so today we want to do two things. One is to understand the origins and motivations behind this amendment. Where did it come from? I sent a Twitter to you just a few minutes ago. Shows that as way back as October, there was already an attempt to push through this amendment. So we'd like to know what were the motivations behind it? What are the motivations behind it? How do people like Jonathan Moyo become so central to this matter? We were interested in that. And I hope that Justice in particular, but also others might be able to assist. I think it's very important to know what is the plan, what is 2030 all about, of which this amendment number 3 is the basis for it. Secondly, we want to strategize and agree on the way forward in terms of defending the Constitution. And we have here the convener of the DCP to assist us in that matter. And thirdly, we have Orbit Masaraure from ATUS, one of the biggest unions in the country, some 500,000, mainly teachers who are the backbone of our, one might say, of civic society in Zimbabwe. What is the response of the working people to this assault on the Constitution? What are they likely to do in supporting the defense strategy that the DCP and CDF and others have put on the table? So, without much ado, I will now ask Justice Mavedzenge to start off for us. Justice.
Thank you very much, Professor Mandaza. Can you hear me?
Yes, we can hear you very clearly.
Fantastic.
Good and we can afternoon. See you too.
Awesome. Good afternoon and good evening to everyone that has turned up to participate in this meeting, and hopefully we will be able to provoke further questions to enable people to engage first with the bill itself, but secondly with the politics surrounding the bill as well. What I intend to do, Professor Mandaza, is to first deal with the legal position because I think by its very nature, the constitutional amendment bill is a legal proposal. So I think we need to be on the same page in terms of what the legal position is. What are the correct procedures to be followed when introducing such a bill as the one that we have before us? After that, I intend to address some propaganda myths that I think have been flying around. Some, I believe, are acts of mischief, by those that are seeking to mislead the public. I think some are probably just figment of imaginations by those that are in denial of the real legal position that is obtaining in the country in respect of what the Constitution says. In the process of doing that, of addressing the myths and realities, I will also attempt to share my perspectives on what I think are the origins of this. So let's deal with the law first, and hopefully quickly, then we can get to the other stuff. Because I think the law has been explained over and over again, but it is necessary for us to explain it again, especially in the context of the propaganda myths. The first thing to appreciate, Professor Mandaza and colleagues, is that the bill that is before us proposes a raft of changes to our constitution. Some of the changes that are being proposed affect what in constitutional law we call changing the basic structure of the constitution. In other words, every constitution of any country has a basic structure, which comprises things or principles of governance, or the core principles of governance, such as separation of powers, universal suffrage. Those are some of the core or examples of core principles of governance, which shape the design of the constitution. And there are some changes, there are some proposed changes in this bill which seek to alter or to change, to redesign the basic structure of our constitution. And I think any responsible leader, when they are introducing those kind of changes, regardless of what the Constitution says, any responsible leader who is introducing changes to the basic structure of the Constitution, any responsible leader would find a way to make sure that the people are given an opportunity to decide directly. But that's besides the point. Let me just enumerate some of the critical changes that are being proposed in this bill, so that when we say Constitutional Amendment Bill number 3, we all have an idea of what we are talking about. The bill proposes a raft of changes. I tried to count them, to enumerate them. They are in excess of 10. And one of them is it seeks to give the president the power to appoint 10 more senators, seeks to create a constitutional body which is going to be called the Zimbabwe Electoral Delimitation Commission, which basically is going to take over functions from the Zimbabwe Electoral Commission, functions to do with the delimitation of electoral districts in our country. Thirdly, it proposes to transfer voter registration functions to the Registrar General. Basically, it proposes to get us back to the situation that we were in before the negotiations around the global political agreement began, where a man at that time called Tobayo Amadiede, who was the Registrar General, was the presiding officer when it comes to voter registration. And there were so many problems, which I hope in the course of tonight we'll be able to revisit some of those problems, which really led us to, as a country, to say, look, I think it's best that these functions be moved to an independent constitutional board, or to what is supposed to be an independent constitutional board, the Zimbabwe Electoral Commission. The fourth proposed change is expanding the jurisdiction of the Constitutional Court. The current jurisdiction of the Constitutional Court is limited to deciding or making final decisions on all constitutional matters. When we say constitutional matters, we are talking about matters that involve the interpretation of constitutional principles, interpretation and application of constitutional provisions. So the Constitutional Court is the final court on such matters in Zimbabwe. The bill proposes to expand the jurisdiction or the mandate of the Constitutional Court to now decide any matter of public importance. I foresee some serious challenges going forward with respect to what is a matter of public importance. It's a very strange formulation. But again, those are things that can be ventilated going forward. The fifth proposed change is that the bill seeks to give the president powers to appoint judges without any meaningful checks and balances. The current process of appointing, or rather the original 2013 constitution, when it was adopted, created a process of selecting and appointing judges, which was led by what is supposed to be an independent body, the Judicial Service Commission. And the president was required to act in accordance with the recommendations of the Judicial Service Commission. In other words, the recommendations of the Judicial Service Commission were binding on the president. The idea behind that rule or that procedure was to ensure that the independence of the judiciary is protected and safeguarded by making sure that the process of appointing judges itself is one that is led by an independent body and is removed from the purview of politicians. So the bill seeks to reverse that and give the president expanded powers. The bill also seeks to repeal the Gender Commission and transfer the functions of the Gender Commission to the Human Rights Commission. The bill also seeks to remove the constitutional rule that prohibited traditional leaders, including chiefs, from taking part in political party activities. The bill also seeks to now change the way Zimbabweans elect the president by introducing a system where the president is elected by parliament. The bill seeks to extend the presidential term of office from 5 to 7 years. And the bill seeks to extend the current president's term to 2030. So those are the key proposed changes that are sort of contained in this bill, and there are more. But those are the key changes that have an impact on the basic structure of the Constitution. In other words, they have a direct impact on the core principles of governance, which Zimbabweans have agreed to be the basis of their constitution. Now, It is important to, when analyzing this bill from a purely legal point of view, it is important to make a necessary distinction. It is important to distinct between proposed changes which require a 2/3 parliamentary majority and those which require a national referendum, right? The proposal to extend the presidential term of office from 5 to 7 years requires a national referendum. In other words, that change cannot be adopted without the approval of Zimbabweans through a national referendum that is held in conditions akin to a free and fair election. So in other words, the referendum must be held in an environment where Zimbabweans are free to express themselves on whether they would like the term of office for the president to be extended from 5 to 7 years or not. So it's a question that has to be framed in such a way that Zimbabweans vote yes or no. Just like in 1999, we were voting yes or no on the entire constitution. Then in 2013, we did the same thing. But in this instance, it would be a question, a referendum question, a question that is framed, but in such a way that you either vote yes or no. So it would be something like, do you agree? Do you agree that the presidential term of office be extended from 5 to 7 years? So yes or no, right? Simple as that. But that is what the Constitution requires. That's number one. Number two, the proposal to extend the term of a sitting president requires two national referendums, right? When I'm saying the proposal to extend the term of a sitting president, that is different from proposing to extend presidential term of office. So you can say we are proposing to extend the term of office for the president from 5 to 7 years. Then you also say, in addition, we also want to extend the current term of office of the current president, or the term of office of the current president, in this case, President Mnangagwa, whose term of office is supposed to end on the 6th of September, or by the 6th of September, 2028. What this bill that we are looking at seeks to do is to extend his time in office from 2028 to 2030, right? Now, for that to happen, you need two national referendums. One referendum to, well, let me explain why. Why? Because there is a specific section in our Constitution, Section 328, subsection 7, which says, if you want to change the term of office for the president, you need to ask Zimbabweans through a referendum whether they want or they approve or not. That's simply what it says. Then it says, however, even if Zimbabweans approve the change in the term of office, that change cannot be applied to benefit the sitting president. In other words, President Mnangagwa cannot benefit from a change of term of office from 5 years to 7 years. He would still have to end his term in September 2028 because the change cannot be applied to benefit him. This is what Section 328, subsection 7 says. It's not my words. That's what it says. So the only way to get around that is to do a referendum in which you ask Zimbabweans whether they want President Mnangagwa to continue in office or not. And then you do another one to amend the provision which prohibits President Mnangagwa as the sitting president from benefiting from a change in terms of the term of office. That is what the Constitution says. But let me go a little bit deeper, so that maybe this particular point can be clearer to some amongst us. So constitutional bill number, so you will see that in my presentation, I'm dealing with two issues here that I think have proven to be extremely contentious. The proposal to extend the presidential term of office from 5 to 7 years, and the proposal to extend President Mnangagwa as the sitting president's term from 2028 to 2030, have proven to be very contentious. And I think for the right reasons, because government is not following the right procedure in processing those two proposals, right? We can have a discussion about other proposals in terms of whether they are good for the country or not. I've already indicated my position when I was enumerating them. But these two are extremely problematic, and the public discussions are focusing entirely on them, because government is using the wrong procedure in processing these two proposals. Specifically, what Constitutional Amendment Bill number 3 seeks to do is it seeks to amend Section 95, subsection 2 of the Constitution by increasing the term of office for the president from 5 to 7 years. And the point I've been making up to now is that that particular section of the Constitution, 95 subsection 2, is a term limit provision of the Constitution. Now, how do we know that it's a okay? In fact, the controversy is if Section 95 subsection 2 of the Constitution is a term limit provision, which if it is amended will elongate or increase the length of time that one serves in an office, then the proposed change can only be processed after or through a national referendum. But if it is not, then you can process it through a 2/3 parliamentary majority, and that would be sufficient. The challenge here, comrades and friends, is that Section 95(2), which is explicitly targeted in the bill, is a term limit provision of the Constitution. Now, why do we say that? We say that because if you go to Section 328, subsection 1 of the Constitution, you will find a definition of what a term limit provision is. So the drafters of this Constitution and those who negotiated it were careful enough to include a definition of what a term limit provision is. And when they did so, they framed that definition in very plain words, very simple words, but in an emphatic way. And I will explain the reason later, but I just want to deal with what it says. So Section 3281 defines a term limit provision as a provision of the Constitution of Zimbabwe, which limits the length of time that a person may hold or occupy a public office. The length of time that a person may hold or occupy a public office. I think I would encourage all Zimbabweans, regardless of our divide or where whatever we do in life, just go and read that particular section 328, subsection 1. It's written in such plain language. And I think it was for the reason such as it was designed for times such as we are in now, to make sure that there's no confusion about what a term limit is or what a term limit provision is. It is a provision which limits the length of time. Now, in Zimbabwe, a person who is elected to serve as president is elected to serve for 5 years. I think this is something that all of us know. Why? Because every 5 years, we elect the president. Right? So a person is elected to serve as president for 5 years. Section 95(2)(b) defines the length of time the president can occupy that office. It sets the term at 5 years. That's what it does. So you go and read it again, section 95(2)(b), you will see that it says term of office for the president is 5 years, and it is calculated together with, and it runs parallel with the term of office for parliament. Now, there are two critical judgments that have been made by the Constitutional Court of Zimbabwe to underscore the position that Section 95, well, two positions. One position, which is that the term of office for the president is limited to 5 years. And the second position, that Section 95, which the bill is targeting, is actually a term limit provision. There are two Constitutional Court decisions that are there, which I think many Zimbabweans would be aware of. One is the decision of the court in Julius Mawarire versus Robert Mugabe, president of Zimbabwe at that time, decision of 2013. There was a whole discussion in that court case around when are elections in Zimbabwe due. You know, you would recall, some Zimbabweans would recall that what necessitated that question was that ZANU-PF had taken a position that they wanted to call for an early election. And the MDC, as a co-governing party in the government of national unity at that time, was saying, no, elections are only due later on after six months. And the reason why the MDC alliance had taken that position is because they wanted electoral reforms to be implemented. But it was not just the MDC which had taken that position. The SADC facilitator, at that time, former President Jacob Zuma, had also taken that position. This is public information. He had taken that position that no, Zimbabwe should only go for elections after implementing the electoral reforms contemplated in the constitution. And ZANU-PF said, no. We may agree or may not agree that the constitution requires us to implement electoral reforms. But the law is the law. And the law says elections are due at a particular point, at the end of the 5-year term of parliament and the president. And the Constitutional Court ruled in favor of ZANU-PF's position. Of course, ZANU-PF was not the applicant on paper, but the court ruled in favor of ZANU-PF's position and said the term of office for the president, the term of office for members of parliament is 5 years. Right? So we have clear jurisprudence, we have clear clarification from the Constitutional Court on the interpretation of the length of term of office for parliament and for the president. But to be honest with you, even if we didn't have that decision, we know the length of the term of office for the president because we go for elections every 5 years. But for argument's sake, we have a Constitutional Court decision. that underscores that position. Then the second Constitutional Court decision is more recent. It's a 2021 decision in a case titled Max Mupungu versus Minister of Justice. And I think some who have listened to our conversations on this topic have heard this decision said. But for the sake of others who probably may not have heard about this decision, I'll just summarize that this particular decision deals with the question whether Section 95 of the Constitution is a term limit provision or not. But what was this case about? This case was about an applicant, or rather, there was a challenge to President Mnangagwa's decision to appoint Chief Justice Luke Malaba to serve for an additional 3 or 4 years. I can't remember the exact number of years, but for an additional period of time. After he had or was supposed to retire in May 2021 when he reached the age of 70. And the Constitutional Court made this finding, and I need you to work with me there, because that's where a lot of propaganda has been going on, and you need to read that decision for yourself and understand it, so that you are not confused by what politicians are saying. The court said there's a distinction that is to be made between age limits and term limits. So the first lie that is being peddled by some politicians is that the court's decision in Max Mupungu was not dealing with term limits. That's not true, because the real controversy that necessitated that court action was the belief amongst the belief by the applicants, starting with the High Court action, the belief or the view of the applicant that the president had illegally extended the term limit of the Chief Justice. So the court was actually dealing with a subject matter that involved term limits. The fact that the court did not agree with the applicant and agreed with ZANU-PF's position at that time, interestingly, does not necessarily mean that the court was not dealing with term limits. The court was dealing with the question of term limits. And this is the reasoning that the court gave. The court said, we have to differentiate between age limits on one hand and term limits on the other hand. So the court is talking about term limits. Then it went on to say an age limit in terms of our constitution in Zimbabwe is a provision of the constitution which sets the maximum age, the oldest age, until which one can occupy the office. In this case, one can act or serve as Chief Justice of the country. That's an age limit. Term limit is the provision in the Constitution which defines or limits the length of time that a person may serve in that office. This is what the court said. Go and read from paragraph, from pages 48 to 51, but specifically 50 to 51. Now, so in making that drawing that distinction, the court then went on. So can you mute so that Senator Timber, can you mute? Thank you. So sorry about that. So the court went on to then point out that what the president had done at that time was to change the age limit and had not changed the term limit. Then the court went on to say there are a range of term limits in the Constitution, and it enumerated them. And one of the term limit provisions which was enumerated by the court is Section 95 2B of the Constitution. Right. So this is why I am saying they should not, in a normal situation, there shouldn't be a debate on this particular question as to whether Section 95 subsection 2B is a term limit or not. There really shouldn't be a debate on this because the Constitutional Court has ruled on that particular point. And it has ruled clearly. Of course, I've heard others saying, no, look, but it's an important, the question whether the presidential term of office can be extended or not is an issue that must be ventilated by the court on its own. I don't quite understand that language, that reasoning, because the court in the Max Mupungu decision was dealing with whether the president had changed the term of office of the Chief Justice, who is the head of the third branch of the state. And in a normal constitutional democracy, at par with the president. So there's really nothing that makes the president more special than the Chief Justice. So much that, we must disregard what the court has said precisely because matters to do with the president have to be dealt with separately. There's no separate rule of law system in Zimbabwe. There is a rule of law system that applies to everyone, whether it's the president or whether it's me as an ordinary citizen. And the Constitutional Court ruled that term limit provisions are provisions which limit the length of time that someone spends in office. And Section 95 2B is one such term limit. So we should really not allow ourselves to be confused by some politicians on this particular point. Now, let me move on to addressing specific myths, specific propaganda myths. I've already attempted to address some of them, but there are some that I think are important to deal with, so that Zimbabweans are really very clear about what is going on here. So one myth that has been propagated, I think for a week or a week and a half now, is that this bill is not seeking to change term limits, but it is simply changing electoral cycles. So this does not make sense because it is impossible to change electoral cycles without changing the length of time that a person serves as president. So this particular bill seeks to postpone the general election from 2028 to 2030. That's what it is doing. How? By lengthening the term of the current president. So if you are lengthening the term of office of the current president, it means that you are removing a limitation that has been placed on the length of time that the current president can serve in office, which means you are amending a term limit provision. Let's go back to Section 328. It says, a term limit provision is a provision of this Constitution which limits the length of time that a person may hold or occupy a public office. So my point is, if you are postponing the general election from 2028 to 2030 by lengthening the term of office of the current president, you are increasing the length of time that the current president will serve. How? By removing the limitation, which was saying his current term ends in September 2028. So in my view, when the minister, because I think it was the Minister of Justice who said this, when the Minister of Justice said, look, we are just changing term limit, we are just changing electoral cycles, we are not changing term limits. I think he was effectively admitting in a court of public opinion that they are changing a term limit provision and they should be planning to hold a national referendum. The second myth that has been propagated is that a term limit provision is a provision that limits the maximum number of times a person can serve as president. I need to repeat that. The second myth is that a term limit provision is a provision that limits the maximum number of times a person can serve as president. So their argument is, look, President Mnangagwa is entitled to be president up to a maximum of 2 terms. First, he is not entitled. There is no such entitlement, or there is no such right under the Constitution of Zimbabwe. It says a person is entitled to serve for 2 terms. But I will deal with that later. The first thing I need to deal with is that this argument is illogical. Well, let me actually deal with it right away. This argument is illogical because no one is elected to serve for a maximum of 2 terms in Zimbabwe. No one. If you show me in the Constitution where it says the president is elected to serve for a maximum of 2 terms, there's no such provision in the Constitution. The president is elected for a single term at a time, limited to 5 years. And this is in terms of Section 95(2). What you have in Section 91(2) is a set of provisions that deal with qualifications for election as president. And what some of the mischievous politicians are doing is to deliberately conflate Section 91(2) with Section 95. And as I say, Section 91(2) deals with qualification for president, for election as president. In other words, it deals with eligibility requirements which one must meet in order to be considered for the job of serving as president. While Section 95(2) regulates the length of time the person elected can serve in that office. So, maybe so that it can make sense to some of us. A lot of us have either applied for jobs or you have recruited an employee and appointed them into a position. So in a normal recruitment process, Section 91(2) of the Constitution would be a provision that sets out the minimum requirements for shortlisting the candidates who qualify for the job, while Section 95(2) defines the length of time of the contract or the length of the term of contract. So Section 95(2) is the term limit provision because it defines and limits the length of time the employee can serve in the job once appointed. But again, you just need to go back to Section 3281 and read what it says about what a term limit provision is. It is about the length of time, not the number of times that one can apply to be. You see, the president is elected for 5 years at a time in Zimbabwe. That's the term, 5 years at a time. Then the third myth is that the Constitutional Court's decision in Maximo Pungu versus Minister of Justice is obiter. We are not bound by obiter. It's just a suggestion that was made by the court. This is what some of the people who are propagating this bill are saying. So the term obiter is Latin, if I'm correct. It's a Latin term. Obiter dicta means comments or observations that are included in a judge's decision or ruling. And those comments are not essential to the decision. Right? So I need you to follow two aspects there. Comments that are not essential to the decision. Comments, that's number one. Two, not essential to the decision. That's what an obiter is. So if it's just a comment or a suggestion, and if it is not essential to the question that is before the court, then it's obiter and it's not legally binding. In the Maximo Pungu judgment, the court, like I mentioned earlier on, was addressing the question whether the decision by the president to extend the age limit from 70 to 75 years for the Chief Justice should be regarded as an amendment to the term limit provision or not. So the central question in that court was, did the president amend, or did the constitutional amendment which the president had implemented, did that amendment change a term limit provision or not? That is the central question that was in that court case. And as I mentioned earlier, when the court drew a distinction between age limit on one hand and term limit provision. So let's go back to, and then it drew the distinction, and then it said a term limit provision is a provision that limits the length of time, and Section 952 is a term limit provision. That's what the court said. Now, let's go back to the definition of an obiter. The definition of an obiter dicta is that an obiter refers to comments. That's one. Two, that are not essential to the decision. So now let's look at what the court said, and then we can evaluate for ourselves as to whether, when the court said what it said about Section 95, was it just making a comment, and was it not essential to the decision? First, whether this was a comment or not, this was essential for the decision, because remember, I said the central question in the matter was whether the president's decision amounted to extending the term of office or not, and whether the amendment which the president was implementing had changed the term limit provision or not. So when the court said what it said about Section 95, it said something that was essential, directly connected to the central questions for determination by the court. Now, but I want to deal with whether was this just a comment, a suggestion or not. The language used by the court in delivering this ruling is emphatic. It is not suggestive. Let me quote what it said. The court said at page 50 to 51, open quote, as is self-evident, the tenure of all of the aforementioned public offices, including the president, is undoubtedly subject to term limit provision within the meaning of Section 3281 of the Constitution. Now, when the court says something is undoubtedly, that doesn't sound to me like a suggestion or a comment. It is something the court finds to be beyond any doubt. So 7 judges found it beyond any doubt that Section 95(2)(b) is a term limit provision. So let's go back to what an obiter dicta is. An obiter is a term that is used to refer to comments or observations. Now, I respectfully argue that the sentence that I've just read, the quote that I've just read from the judgment, is not a suggestion. The language used there is not of a suggestion. Now, let's go to the second part of what an obiter is. And the comment should not be essential to the decision. I've already demonstrated to you that in making this finding, the court was dealing with a core element of the question before it. So those that are saying the decision of the court in Max Mopungu is obiter, is non-binding, I think either they are just being mischievous or I think some of them are just completely ignorant about how the law operates. The fourth myth, propaganda myth, is that we cannot be bound by a decision of one judge. I think to quote one of, I think it is Professor Moyo who said, no, we cannot be bound by, what an excitable, benign, excitable comment by a judge which is harmless and so forth. I mean, these things are there in public, they're there on Twitter. So you can read them for yourself. I think that's just being either ignorant or mischievous, because the judgment that I'm talking about here is not a judgment by one judge. So this is not a judgment of the magistrate's court, which is presided, where a matter is presided over by one judicial officer, or even in the High Court, some of the cases are dealt by one judge. This particular case that I'm talking about is a case that was so important because it involved the question whether the head of the judiciary was validly in office or unlawfully in office. This was how important this question was. Now, I mean, this case was, and for that reason, the judgment was not a judgment of one judge. It was a judgment that was signed off. It was actually written by two judges, Justice Rita Makarao and Justice Bharati Patel. And when you go towards the last page of that judgment, you see that the Deputy Chief Justice and other judges signed off to indicate that they associate fully with the findings in that judgment. And none of them wrote a dissenting opinion. You see, let me remind you again about the 2013 court decision in Jelas Mawarire versus then President Mugabe. In that case, there was the decision of the court, but the then Deputy Chief Justice, now Chief Justice Luke Malava, wrote a dissenting opinion. In other words, he disagreed with what the court had found and explained reasons why he disagreed. And if my memory serves me well, Bharat Patel J also did the same thing. So I think in that case, we have two dissenting judgments. And there are several of these cases where you find the decision of the court and then you find dissenting opinions from other judges who don't agree with the findings of the court. In the case of Max Mopungu versus Minister of Justice, we do not have a dissenting opinion from anyone. We have a judgment signed and endorsed by all the 7 judges. So I think it is clear that in light of all this, our Constitutional Court has already pronounced itself on this matter. And I think if the government continues with this dangerous amendment, it will be committing a constitutional coup. That's basically what they will be doing. The fifth myth, and then I will end, but it's a long one. The fifth myth is that this constitutional amendment bill is meant to address electoral toxicity. I don't quite understand how you address electoral toxicity by shoving a constitutional amendment through, or rather imposing a constitutional amendment without respecting the right of the owners of the Constitution to authorize that proposed change or not. So you cannot address electoral toxicity by illegally postponing elections and extending your own term of office as members of parliament. Here, I'm not just talking about the president. I'm also talking about our members of parliament who believe that they are dealing with the electoral toxicity. By extending your own term of office without following due process, you can't honestly say you are addressing electoral toxicity. The truth, in my view, is that this bill, particularly the proposed changes that I have discussed this evening, represents an attempt to abuse and subvert the national constitution by at least three groups of people. And you can place individuals in any of these groups if you want. The first group is, and here, Professor Mandas, I'm trying to deal with your question around what are the origins of this bill. So the first group is a group of unelected and unelected hangers on. And these are found both in ZANU-PF and in the opposition. There are people who have never won. Well, they say they are politicians. They say they represent the public, but they have never been elected. And every time they've attempted to contest in an election, they've lost. Including elections within their own political parties, primary elections, they've lost. Then you also have, particularly in the opposition, people who found their way into certain positions by way of abusing, or they're just beneficiaries of abuse of the rule of law in the country. But no one actually elected them into those positions. Now, these people, in their view, they can only survive politically if President Mnangagwa remains in office. And they cannot afford to allow a national referendum, because doing so would most likely defeat what they are trying to do. But I also think that these individuals have a very traumatic experience with elections. They hate elections. So perhaps when they are talking about electoral toxicity, you must understand that they are not talking about the toxicity that you and I have in mind. What they have in mind is essentially fear for elections. They are afraid of elections. They've
It's going to wind up now. It's going to wind up, Justice.
Yes, they've post-trauma disorder concerning elections, because they've consistently lost, and they believe now that the only way they can survive politically is if President Mnangagwa remains in office, and they hope that he then can either appoint them into other positions or keep them in their current positions. The second group is, in my view, is a group of exiled opportunists who can only return to Zimbabwe without facing justice for their crime, who think that they can only return to Zimbabwe without facing justice for their crimes, because they hope that by helping President Mnangagwa to extend his term, he will forgive them and he will protect them, because he will feel indebted to them. You can clearly see that this is probably, some of these people yesterday told us that the reason for electoral toxicity in Zimbabwe is President Mnangagwa himself. But today, then they say, no. President Mnangagwa is trying to deal with electoral toxicity. Then we ask the question, but what has changed about President Mnangagwa? They can't really tell us anything that is tangible, except that they think that he must remain in office. The third group is a group of corrupt individuals who believe that if President Mnangagwa leaves office, they may have to account for their shenanigans. And I think these three groups of people have all congregated to find a way to abuse and subvert the national constitution in order to address what appears to me like personal crises. These are personal crises, personal quagmire, which they are trying to address by way of plotting a constitutional coup. Now, in conclusion, two things. One, to the extent that the government is proposing to process Constitutional Bill number 3 without following due procedure, I think they are seeking to subvert the Constitution, but in ways that are akin to a constitutional coup. And I think this must be stopped, and I challenge Zimbabweans from across all divides to unite and find ways to stop this. And if those pushing for this bill are so confident that Zimbabweans want President Emmerson Mnangagwa to continue, and to continue beyond his current term, and if they believe that Zimbabweans want their president to serve not for 5 years, but now for 7 years, then why are they so afraid of a referendum? Thank you, Professor Mandas.
Thank you, Justice. I gave you a long time, but necessarily so. I think you did a wonderful job in outlining the contents of this amendment number 3, including provisions such as those that take us back to pre-2013 constitution, and one has to really, although you think that they are less important, I think they are very crucial, because it amounts to reversal of the constitutional provisions that were brought about in 2013. It's serious, in my view. Anyway, I will come back to you. Let me go to Jameson Timber. Jameson?
Thank you very much.
I'm sorry that we took long with Justice, but I think you'll agree it was necessary to have that outline the way he has put it out. Yes.
Justice did justice to President. Was 7 years old during the case question, 1971. And I was coming out of where I was watching a movie, and the riots outside. To vote no against the PS Commission. So I really enjoyed you taking us back to the PS Commission, Ibo. Zimbabwe faces a difficult crisis at the moment. A crisis which takes us back to where we were before 2008, when the key political actors in this country sat down and said, listen, we can't go on like this. We need to move the country. And one of the key things that they agreed was to come up with a new constitution. That new constitution, as much as it was possible, it is not a perfect document, but intended to take into account the interests of various segments of our society, including the ruling party. And all the issues that we had were put on the table. And there was deliberate consultation of the people throughout the whole country to hear what Zimbabweans wanted in their constitution. And they spoke loudly. One of the key things that they said then was that they wanted a president who serves for 2 terms of 5 years each. That request was made almost throughout all the public hearings that were held in all the provinces in Zimbabwe. It was a key demand of the people of Zimbabwe. People of Zimbabwe then went to a referendum and agreed on this constitutional settlement. What is being proposed by Bill number 3 today is a reversal of those democratic gains that Zimbabweans settled in 2013. But most worryingly, Dr. Ibo, is the fact that the changes that they intend to do to the Constitution itself is forbidding those changes unless people are consulted through a referendum. I do not understand why, if the ruling party believes that these proposals have got popular appeal, why can't they just go back to the people? Because the people are here and they are willing to speak. Just go back to them and say, listen, we would like to extend our tenure. So this idea of wanting to do these amendments through Parliament is not acceptable. As the DCP, we are here lawfully to confront the 2 crises that the country is facing. The crisis related to the mutilation of our Constitution and the crisis related to the non-implementation of that Constitution that we agreed in 2018. All we are asking is that implement the Constitution, do not amend it. That's all we're asking. If you have to amend it the right way. So which means give us a referendum. If you do not give us a national referendum, then the DCP will organize a people's referendum where the people must speak and exercise their rights in terms of Section 59 of the Constitution of the Republic. There is no other way. And we are saying to Parliament, to parliamentarians, you were given a term of office for 5 years. You have no right, moral or otherwise, to extend your own term of office. You can't. You simply cannot do that because it's morally reprehensible to do it. Go back to the people, ask for, demand that there be a referendum, and then that's it. But if we look at the totality of the bill, what is the position of the DCP? We've taken the position that the Constitutional Amendment Bill number 3 is indivisible, which means Parliament shall have to face all the clauses that are being proposed to be amended in the Constitution. And they must say yes or no to everything. We can't pick and choose. So in that regard, the DCP is saying, we reject the bill in its entirety, but still make the demand that any changes to terms of office or to term lengths must go to a referendum. If that doesn't happen, then there's no legitimacy. Any processes coming out of that through just a parliamentary process will be illegitimate. And to us, that would constitute a constitutional coup. Zimbabwe is signatory to various instruments, including the constitutive documents of the African Union. In the AU, he has expanded its definition of a coup to include constitutional manipulation, which would result in an abuse, for instance, of sovereignty or of the will of the people, by using the procedure of the Constitution to do that which the Constitution itself forbids. So we are saying we will exhaust our domestic remedies here in Zimbabwe, including going to our courts, the Constitutional Court, and raise our concerns. But in the event that we do not get remedies domestically, then as the DCP, we will approach the various international fora available to us as Zimbabweans and as members, as citizens who are of member countries of the African Union, who will raise this matter internationally. But I'm still appealing myself to the good senses of President Mnangagwa, that he still has time to reconsider or take a definitive position himself as the leader of the country, to say we cannot take our country through this path. Zimbabweans are saying no. And for his own legacy, I would say that, Mr. President, please reconsider your position. Those would be my general remarks, Ibo, and I'm available to answer any questions.
Thanks, Jameson. Thanks very much indeed. Very brief and to the point. You outlined the position of the DCP, which is a position that most of those who are defending the Constitution are obviously taking, to exhaust all domestic remedies before approaching the AU. But also you're appealing to the head of state, who has previously, on several occasions, declared that he's a constitutionalist. And very recently made a statement criticizing those who were claiming that he was extending his term of office. So I'm sure that message has got across. Thanks, Jameson. Before I come back to
Thank you.
questions which I have for you, I think I'll bring in Obert Masaraure. Obert, I hope you're still there with us.
Yes, I'm here, Prof. Greetings, viewers.
Thanks.
Thank you so much, Prof, for having me here.
Yes.
Okay, so for me, the question really is, I'm here, of course, on behalf of the Amalgamated Rural Teachers Union of Zimbabwe, but more importantly, I'm also here on behalf of the dispossessed mass of our people. And we are here, and we believe we have a unique opportunity. In the past, we have had to deal with an organized, well-oiled and well-coordinated machinery of the elites, they were coordinating exploitation and oppression of the masses of our people. The state, with its different arms, the parliament, judiciary, the executive, all conniving to ensure that they extract as much surplus value from the people as they can and oppressing them in the best manner possible. But we find a unique opportunity for us because we find one person who is trying to dribble all the institutions of the state, is even trying to dribble the whole infrastructure of capitalism and try to create a super president for himself, a super president that is not responsive, that doesn't answer to parliament, a super president that doesn't answer, that can be held accountable by the judiciary, a super president that can even define who succeeds him, who also controls, who reduce the whole economy into his dark shop. So someone who wants to run a fiefdom of sorts. So we find ourselves in a unique opportunity where we are saying, maybe it's time to recreate a new consensus as a nation, to say, now that we have this opportunity created by this man who is super obsessed for creating power for himself, Ambokoshe as an individual, is this not an opportunity for us as Zimbabwean, the citizens, to come together across party lines, even the former oppressor, to reach out to those who they used to oppress and say, let's come together and work together? And why I'm saying is trying to dribble everyone. Nyaya yacho yavedzengwa ikatimbwa nakomajasi ikatimbwa navatimba zvakanyanya zvinooneka, but I'll just give quick highlights so that people appreciate that I'm not just shooting from the moon, from the blue. The evidence that one man wants to own Zimbabwe is so clear, and our biggest question to him, so if you go and look at these amendments, you find an attempt to disregard clearly define what kind of nonsense is that? You can't. We need 2 referendums. You just want to introduce a phrase to insert it. So the whole idea of these amendments is just to keep one man in power. But then those who still have doubts can just go and look at the proposed amendment, section 92(8) in particular. If we are saying we now have a parliament that can elect a whole president, but if you read the section 92(8), it clearly states that no amendment to any law or enactment introducing substantive policy changes shall be passed by Parliament during the period where the office of the president is vacant. Now, they're trying to convince us that we want to model our new constitution along the lines of South Africa in Botswana, among others. But if you go and read the South African constitution, particularly section 102, it is so clear that Parliament remains in charge. They continue to make laws, even when the office of the president is vacant. The speaker becomes the president. So the idea really is not to empower Parliament, to have a strong Parliament, but the idea is to have a super president who owns Parliament. So no wonder why this men want to be super president, wants even to appoint additional senators to say, I want to bring 10 more of my people. No wonder why this man wants even to say, the traditional chiefs, 18 of them who sit in Parliament, they now should be partisan. Because he knows that when they have become partisan, they are now his subjects. But when they are just traditional leaders, they might not toe the party line. So, you have a Senate where you have 28 senators that are already in his pocket out of 90. And that is a big percentage. If you are going to be looking at the proportion of people who sit in that Senate, that's more like that's like 30% of the senators that are already in his pocket before even Zimbabwe votes. And now when Zimbabwe votes through the proportional representation system, you realize that even if there is an opposition that can garner 70% of the proportional vote, they will still won't have enough numbers in Senate to have a majority. They only have 49% of Senate. So what this means is him and maybe his successor, a son or a friend, can then have even if they have 30% of the vote, they can still control Senate, because the opposition that would have 70% of the will of the people would have been cast in favor of the opposite. But him or the successor will have a control of that Senate. But then you go on, even if that Parliament where people are saying they are directly electing the leader at the constituency level, he no longer wants to see ZEC doing delimitation. Why? Because we know what happened when Ziambi was so angry with the delimitation report from ZEC in 2023. He was all over complaining about the formula. We know what Tupraito Garepe and this ad hoc committee did then, complaining about ZEC, because the whole idea for them was that delimitation should have delivered the 2/3 majority for the equipment. And they are we were angry with the delimitation report ourselves because it was flawed. But it was not flawed enough to give them the 2/3 majority that was supposed to be automatic for them the way they intended. Now you want He wants really to get back to ZEC and say the powers to draw boundaries of constituencies, I want to give them my friends. He can even get people from FAS to do delimitation and produce a delimitation report. And what does that mean? So it means that even with the 30% of a national vote, him or his successor, we're no longer speaking of ZANU-PF here, because even ZANU-PF members are being disenfranchised here. It's just him and his friends. So when he gets that opportunity, even with 30% of the vote, they can draw the boundaries to ensure that they get the majority of the seats. Since it's not proportional representation in parliament, those are now. So you can see through the malice, you can see through the mischief. If they were genuine about strengthening parliament, strengthening the people's voice, why didn't they choose to go through the proportional representation route? Because they know they would lose. So they would want them to then use the delimitation process to draw boundaries for themselves and ensure that they have the maximum number of seats as possible. And then even without the people's mandate, technically, they will continue to remain in power. So this idea of them saying we're taking powers from ZEC, giving them to the Registrar General, these are all shenanigans meant to strengthen his hold on power and possibly his successor's hold on power. We know what happened with the Registrar General at some point at Heathcliff in 2008. There was a family where one household, a place which was not even built, there were 8,000 voters in this voters row. We know when Morgan Tsvangira had to go to court in 2002, that in Toba they had failed to produce a consolidated voters row. We know the failures of Toba when he produced the Registrar General's office, when they failed to, when over 750,000 potential voters were disenfranchised. They would go to a polling station with a voter slip, but you would find your name not on the voters row, because they are so clear when they come to disenfranchising. ZEC, with all its limitations, they tried to play nice, which is obviously what infuriated this person in office who wants to stay in office until he dies. This idea of going 2030 is a lie. What will stop them if they've changed the constitution to say they'll stay up to 2030? Maybe there's still toxicity, there's still developmental agenda unfinished. They would want to go to 2040. So what we should agree as Zimbabweans is that this amendment bill is just simply meant to completely close the democratic space and ensure that there's no longer any form of transition that will come through the electoral route. But we are saying it's not only targeting the traditional opposition that we used to know, but it's targeting everyone, including people, his own supporters. And they like to us that they want to have a developmental agenda. But some of us know that the development comes from below. People know what they want. You can't impose development on the people. There can never be development without the involvement of the people. People have to democratically decide how they want to develop. We've seen how development has made people poor. You go to the Omo Valley in Ethiopia, where development forced a lot of people who used to have meals to go hungry, get displaced, among other things. They got a bigger dam in the sugar plantations, among other things, but they were hungry. Was that the development was not for them. If you go to Mtoko today, you would be a total development, but you see families being displaced, the mountains being flattened. You go to Bikita, people no longer have drinking water in the name of development. So we don't want development that is imposed from above. We want development that we co-create from below. So they should never extend the term of office in our name. We don't need their development. We define our development. That is why we have always insisted as a coalition of the dispossessed, which is fighting for a better Zimbabwe, to say we need the devolution, we need each and every community to be defining their future, their destiny. So instead of them trying to amend what we've expected them to be strengthening devolution, among other things, they want to tell us that they want to deal with toxicity. We know that toxicity is in ZANU-PF's DNA. All the toxicity we suffered in Zimbabwe is because of ZANU-PF. If ZANU-PF is fed up with toxicity, they should simply do a moral reset, a cultural reset. They should not tamper with our constitution in the name of dealing with toxicity. They know how toxic they've been. They know what makes them toxic. Let them attend to those particular issues. And the constitution has nothing to do with it. Our constitution is a beautiful bill of rights that gives citizens right to education, right to fair wages, among other beautiful things. We don't get them because of a toxic government. So let them address their toxicity but stop tampering with our constitution. As the people, we know that our strength only lies in us enjoying our Bill of Rights. And how do we enjoy it? We can only enjoy it when we have a court which is not captured by this wannabe super president. We want this court to be able to protect our rights. We go there when you are displaced and you say, I've been unfairly evicted, and the court grants you permission to go back. But imagine if you are evicted by one of Nanga's sons who want maybe a mining claim where you are staying. Is the court going to protect you when the judge in that particular court know that this judiciary is now in the pocket of the executive? It's not possible. Our second theater of protecting our rights is the streets. And now when we know all the democratic space, Section 59 is now just a suggestion, is no longer even respected. How do we even ensure that we defend those other rights using the street? So we are at a level where we are saying we need really to ensure that we enjoy our rights, but we will do it through blocking these amendments. But we are also appealing to people who traditionally thought they were oppressing us together with this current president. No, you are not in it together. He's in it alone for himself and his cabal. And now our message is to say to the traditional chiefs, remember how you used to be respected. You will be a traditional chief for everyone. When we had family disputes, we would approach you and ask you to be an impartial arbiter. Do you think we are going to come to you when we know that you are now partisan? And now, as a traditional chief, you used to be respected by everyone, but now you have to respect your district ZANU-PF chairperson because you are forced to be subordinate to a district chairperson. Why don't you demand your independence? Join us in rejecting these amendments, because they erode the value of the values system of the traditional leadership, something that we've adored so much. Look at even those people in ZANU-PF. You used really to have powers to say when you are fed up with the current government, with your own leaders, you would elect government leaders of your own choice. You would reject some leaders you didn't want at primary elections. But with this system, you can reject someone from being a councillor at primary level. But if they have enough money, they can go and buy the whole parliament, become your president, whether they want it or not. Let's fight this. Let's retain the little power we have as what that people. We are talking of parliament and council, those who are in there today. You got a mandate from us, the people, to go in there for 5 years. If you want to go beyond 5 years, don't do it in our name. But we now know you, that you fraudulently converted our mandate. But we know that your fraud will not end with this mandate. You go even to steal more from us, and we will try to stop you. It's the state bureaucracy. We want to strengthen our state institution. We want to have a developmental state. We can't have a developmental state if our all state institutions are being eroded. Build infrastructure that strengthens one person's hold on power. So working people, the villagers, you have lost your surplus value for a very long time, but it's now time to say enough is enough. Let's come together and block these amendments. Going forward, I'm also part of the DCP, and I'm glad Mkoma Timber, the convener, has articulated the way forward. The way forward goes beyond negotiating. It also involves us sacrificing our own blood to save this nation and to save the future of our great children. They deserve to live in a better Zimbabwe. We have a duty to complete the liberation of this country. Those who initiated it, but we salute them, but that project was aborted in 1980. It is now time for the next generation to complete that project and ensure that Zimbabwe saves all its people. No.
Are you done, Tizara? Hello? Tizara? Are you still with us? Hello? Tizara, are you still there?
Yeah, and I think my network had dropped. Can you hear me now?
I can hear you now. Yes. Are you done?
Okay.
I have a number of questions for you.
Yeah, but I had concluded my submissions. I
just have one or two questions for you.
Yes. I hope I was audible. I wasn't speaking to myself. I hope I was audible.
You were very, very audible, very, very audible, and very, very powerful. My question to you is how conscientized are the working class, in particular your members, the 500,000, to this subject of the constitutional amendment? Are we not speaking to ourselves? How sure are we that the mass base is with us?
Yeah, so at the end of the day, we have adopted a two-pronged approach. Of course, we are defending the Constitution from further amendments, but we are also insisting with the members as a collective to say we want the existing Constitution to be implemented. So we are speaking the same language because they know that there's a Bill of Rights that still has to be implemented. They're still waiting for their right to collective bargaining. They're still waiting for their right to a fair wage. So they have been in a struggle on a different front of the Constitution. So this is just a layer, another dimension that has been added by the president, and which has obviously agitated people who were obviously trying to. But now they realize that these people want to lock us into internal poverty. If they have superpowers, we are no longer going to be challenging them in the streets or in the courts. So the discussions are ongoing through the leadership structures, through the ordinary rank and file members, from the classroom, even with other civil servants, even with other workers.
What is your? I mean, there's an uncomfortable suggestion implicit in the defend the Constitution platform, or even the CDF. They imply implication that if the Constitution is defended successfully vis-a-vis this amendment number 3, that then there should be elections in 2028. Is that without electoral reforms? Is that the position of the members, your members, the DCP, the opposition in general? Are you with me? Maybe I should direct that at Jameson Timber. Can you take up from there, that question? Is Timber there? Hello, Timber? Jameson? Justice, can you deal with that question?
I can try. I think it's an important question that I think a lot of people have on their minds. But I think what we need to remember is this. Number one, we have serious problems with the quality of elections that are being held in Zimbabwe. We have serious problems with the independence of the Zimbabwe Electoral Commission. We have some serious concerns regarding the independence of the judiciary. And those concerns are valid. But that does not mean we have a bad constitution. It doesn't mean that. In my view, we have a fairly good and democratic constitution. I have analyzed our constitution against the constitutions of other countries, including Botswana, close by, far afield, Nigeria. We are even better than certain aspects of the American Constitution, by the way. In America, there are certain kinds of judges who, the whole process of appointing judges itself is very politicized. It's openly political, right?
But just as Obert said just now, the Constitution has not been fully implemented to this day. More important,
that's my point.
There have been no electoral reforms at all. It's very good on paper, but in practice, we have a dangerous situation.
So my point is, we have two interrelated struggles that we have that are equally important. The struggle to keep our constitution in place, and the struggle to fight for the implementation of that constitution. Sitting down and allowing them to destroy the constitution because they were not fully implementing it anyways, is going to leave us in a far worse position than before. That's the point I was trying to make.
Yes. Now, I don't know where the other panelists are, but I wanted to come to you last in this regard, but maybe I just continue until I see the other panelists. What's a possible trajectory from now to the end of the 90 days? How do you see things happening? What are the possibilities, the various possibilities, apart from the one that we fear most, which is that the amendment will be run roughshod to implementation?
I think there are two possible scenarios. One is what you have just outlined. The other, in my view, is that the process may be abandoned along the way as a result of, a number of factors. One, I think, is if there is sufficient pressure against this proposed constitutional amendment or amendments, some of these amendments, I think it is possible that we will see a change of course, either to allow a referendum or to abandon some of them. Already, or the reason why I am putting that out there as a possible scenario is because, number one, the arguments that are being made in promoting aspects of this constitutional bill are weak in the first place. But that has not stopped these guys before. But the second problem that I think they have, some of them, is that I don't think there is unanimity. I don't think there is consensus even within the ZANU-PF party on these proposals. This is exactly why there's a lot of propaganda. This is exactly why there's a whole campaign, including intimidation of party leaders and party members, to try and whip them to toe the line. I think when you read through Patrick Shinamasa's tweet, where he was changing his position, you can clearly see a man who is under pressure. And to me, that demonstrates the level of pressure, the level of pressure, and in some cases, intimidation. But the reality is that there is no consensus within the party. There is no consensus within the system. The third reason why I think this is a possible scenario is I also think that they chose or they allowed the wrong people to become spokespersons or proponents for this bill. Some of the people that are championing this bill, first, they lack the necessary technical expertise to really engage in the arguments that are opposed to the bill. This is why now they are all over the show in trying to explain the rationale of the bill. But some also of the proponents or some of the people who have either been architects of this bill or have simply inserted themselves as spokespersons of this bill are people who have serious credibility crisis. And you can already see discussions between or amongst public discussions amongst people who are fully aligned in ZANU-PF. You can already see that there's disagreements in respect of whether some of these individuals should be leading this process or not. And I think, for me, that's a sign that Zimbabweans must continue speaking out. But I think also other stakeholders in the region must speak out. There's one reason why the stakeholders in the region must be concerned about this bill is that once you allow a leader of a country to subvert the constitution, essentially perform a constitutional coup, history shows us that coups of any kind, whether military, electoral, or constitutional, spread like a virus. This is why now in West Africa, there's a whole belt that is governed by military juntas. But if you think that those countries just woke up with military coups, you would be mistaken. They started with constitutional coups, electoral coups. Eventually, they had military coups. So I think the region should be concerned about what is happening in Zimbabwe. They should also be concerned because of the potential breakdown of the rule of law in the country, but also potential high risk for instability in the country. History shows us, even including in Zimbabwe, history has shown us that once you allow yourself to continue in a public office, especially as president, because not necessarily because people have voted for you, but because you have somehow abused your power to force your way through, you become beholden to the elites because they are the source of your power. And it's a question of time before those elites turn against you. We saw that with Robert Mugabe. Robert Mugabe forced his way a number of times, but notably in 2008, when he rigged that election in brazen ways. So much that it was very clear to every Zimbabwean, very clear to the world, very clear even to people in ZANU-PF, that the president was not there legitimately. And that's why they ended up in a government of national unity anyway. But one thing that happened since that time is he became beholden. President Mugabe became beholden to those who had masterminded the electoral coup of 2008. And those are the very same people who removed him militarily in 2017. And if you look at the period from 2013 to 2017, it was a period of instability, not just in the country, but inside ZANU-PF itself. So I'm not quite sure how even leaders within ZANU-PF want to survive in that kind of an environment. But the point I was making anyways is the risk for political instability is high, especially if the president extends his term from 2028. The risk is very high, but also the president will move around with this question of illegitimacy hanging around him everywhere and anywhere, right? He cannot, he can try to ignore it, but it will be so vivid and so loud. But it also means that the country will effectively be back to pre-2008. It might look to some today that, look, the opposition is practically dead, and so the president will be comfortable in his position. But I think that's a miscalculation and misreading of the situation, because the president is getting old, and that's a fact. Similar to Robert Mugabe, 2008 going forward. So yes, President Mnangagwa might be an intelligent supremo and so forth, but he's getting old. That's the reality. And I don't know if he will be able to deal with the pressure that is likely to arise once he extends his term of office beyond 2028 without seeking the approval of the people. So I think, so the point I'm trying to hammer around is that there's a high likelihood of political instability, particularly because Zimbabweans in general have expressed their disapproval to this proposal, but they are also angered by the fact that this proposal is being shoved through their throats, whether they like it or not. But more importantly, there is every evidence out there in the public to show that within ZANU and within the system, there is no consensus on this proposal. And those are factors that are likely to create a recipe for disaster going forward.
No, thanks, Justice. Thanks very much for summarizing that way. And as you said, I hope that good sense will prevail ultimately, because even before the 90 days began, the outrage at these constitutional proposals have been resoundingly negative, and I'm glad that this kind of discussion and your contribution in particular will have helped us. I just have a quotation here from Patrick Henry. The Constitution is not an instrument for the government to restrain the people. It is an instrument for the people to restrain the government. Very important. I hope the authors of this amendment number 3 take note of that. A government, the state cannot willy-nilly decide on how a constitution should look like. Least of all, defying the popular will, which is a referendum. So I hope, as you said, that there will be restraining factors, some of which, as you have pointed out, the lack of consensus within the ZANU-PF, the outrage at the blatant nature of these proposals. My other panelists seem to have disappeared because of network problems. I want to bring the discussion to an end. First, by thanking the almost 300 people who joined us on this platform this evening. Thank you for joining us, and it's part of the defense of the Constitution that we're doing through this kind of program. Secondly, to thank my panelists, Justice, for doing justice to the topic, Timba for outlining in detail the position of the DCP, and last but not least, my Treasurer Masaraure for giving an indication of the thinking of the masses. But in all cases, all three have sufficiently, in my view, really exposed the nefarious nature of this amendment and the grossly illegitimate nature of those amendments. There can be no way of justifying them at all. And even the statement by Shinamasa, my colleague, long-standing colleague, to say there'll be no referendum, full stop, when he knows better than most that what is being done is unconstitutional and even illegal, illegitimate. So I thank you. We'll be continuing this discussion in the weeks ahead as part of our duty to bring this kind of discussion to you at home in Zimbabwe, the diaspora, the millions of Zimbabweans out there, and across the globe. Thank you very much, and goodbye.